all that is done this day be for your honor and greater glory through Jesus Christ our Lord. Amen. Say the Lord's Prayer. Our Father, who art in heaven, hallowed be thy name. Thy kingdom come. Thy will be done on earth as it is in heaven. Give us this day our daily bread, and forgive us our trespasses, as we forgive those that trespass against us. And lead us not into temptation, or deliver us from evil. For thine is the kingdom, the power, and the glory, forever and ever. Amen.
This House is in session. Minutes for the meeting held on Tuesday, May 27, 2025, be deferred. Honourable Leader, Government Business.
Thank you, Mr. Speaker. I beg to move that the aforesaid minutes be deferred.
Questions that the aforementioned minutes be deferred. All those honourable members in favor, please say aye.
Aye.
Those against, please say no. We think the ayes have it.
Announcements by Your Honour.
I wish to acknowledge the presence of members from the visiting Republic of South Africa, the Gauteng legislature, being led by Mr. Linda Marweli, acting clerk of the legislature. Can you all please stand? Thank you.
Messages from Her Excellency the President, petitions, papers.
Honourable Leader, Government Business.
Thank you, Mr. Speaker. I'm commanded to lead the tourism linkages policy.
Government notices, private members' notices, notices of questions, reports from select committees, first readings of bills, statements by ministers, congratulatory and/or obituary speeches, personal explanations, motions for leave of absence, oral replies to questions, notices of motions for the adjournment of the House on matters of urgent public importance, orders of the day.
Honourable Leader, Government Business.
Mr. Speaker, I beg to move the suspension of standing orders 6, 16, 18, 20, 42, subsection 5, 43, and 44 for the remainder of the day's sitting.
The question is that the aforementioned standing orders be suspended for the remainder of the day's sitting. All those honourable members in favor, please say aye. Those against, please say no. We think the ayes have it. The aforementioned standing orders are hereby suspended for the remainder of the day's sitting.
Government business.
Government business is the order of the day.
Order number 4, in the name of the Order number 4, sir, in the name of the Honourable Attorney General and Minister of Legal Affairs, to move the second reading of the Road Traffic Amendment Bill 2024.
Honourable Member for St. Joseph.
Mr. Speaker, I stand this morning to move an amendment to the Road Traffic Act, which had been presaged by an announcement made in September of last year on an occasion when the Honourable Prime Minister went to the country to discuss matters relating to law enforcement. In a way, Mr. Speaker, the requirement for us to amend the Road Traffic Act to address a law enforcement issue should really be a clarion call to Barbados and indicate to Barbadians that the crime situation in the country requires a number of inputs. And sometimes those inputs will come from avenues that are not immediately obvious to the members of the public. In September of last year, Mr. Speaker, as a result of a National Security Council meeting and a briefing by the Barbados Police Service, the police service indicated to us that there were a number of initiatives that they wished to see the government take. It's important for me to begin in this place because I want to say to the country that this amendment to the Road Traffic Act is not something from the wild imaginings of the executive. It is not something that represents any last-ditch or desperate measures to tackle issues related to crime. It was as a result of a deliberate request by the police service to say to us, with all that you are already doing, there are some things that would assist us in the way in which we deal with crime. And as simple as it might sound, Mr. Speaker, the matter of tint on vehicles was essentially the request made to us of the police service. Mr. Speaker, a recent occurrence with a member of the police service saw one of us being shown a vehicle in broad daylight. And by one of us, I mean one of the members of this chamber. And that police officer pointed out this specific vehicle and asked the member of this chamber, look at that vehicle closely and look at the degree of tint on the vehicle. That car was completely blacked out because of tint. And the police officer called to the attention of the parliamentarian the degree to which nobody could see into that vehicle, and simply asked the parliamentarian to reflect on a police officer having to approach that vehicle, not knowing, not able to ascertain who was in the vehicle, whether they are armed or unarmed. We sometimes ask police officers to go into situations blindly, without a care for whether that individual has a family, whether the individual has to go home to parents or children or loved ones, without a care for anything other than that the public is protected. Now, Mr. Speaker, our police officers don't ask for a lot. They ask for our support, but they don't ask for a lot. But they have, on this occasion, asked us to change the law in relation to the tint on vehicles to protect ourselves and as a measure, perhaps, to protect them. Because a police officer approaching a vehicle that is completely blacked out does not know whether to go and knock on the windscreen. He doesn't know if a fire will be greeting him when the person opens the door, rolls down the window, or perhaps does neither but just fires a shot through the glass. The ability to ascertain the occupants of the vehicle, what they do in the vehicle, is key in determining how a police officer approaches it. Does he approach it with a defensive stance, a friendly good morning, or does he approach it for fear of his life with a gun almost drawn? Or maybe, Mr. Speaker, he decides that is not worth my life, I go in the other direction. That is what our police officers face. Daily, Mr. Speaker, vehicles drive through our communities completely blacked out. And we know that in many instances, when crimes are perpetrated in broad daylight, far less at night, the individuals roll up in vehicles that are completely blacked out. You can't see anything. Now, Mr. Speaker, it may seem like a small thing, but to protect our society, sometimes a small thing makes a difference. There's that old saying about for want of a nail, a shoe was lost, for want of a shoe, a horse was lost. For want of a horse, a battle was lost for want of a nail. I suspect I have the story not flowing with the poetic melody that my primary school teachers instilled in me, but the point is made. For want of a nail, a battle was lost. But Mr. Speaker, when we say to Barbadians that we're going to do this, this is no novel approach. I have a list of all the Caribbean countries where the level of tint on vehicle is regulated. But you know what Barbados has, Mr. Speaker? Barbados has this road traffic regulations, and for those who want to check, Section 27 of the road traffic regulations, this is what our law has said about tint since 1984. The glass of all windscreens and all windows on the outside of every motor vehicle shall be made of safety glass, not relevant. And the owner of the vehicle shall not permit the glass to be tinted to such a degree as to make the driver of the vehicle unidentifiable from a reasonable distance by a person outside the vehicle. So that is our provision, that the owner of the vehicle shall ensure that the vehicle is not tinted to such a degree as to what? As to make the driver of the vehicle unidentifiable from a reasonable distance to a person outside the vehicle. Now, Mr. Speaker, we would not draft this form of legislation today. This is 41 years old. Because the law itself would say that this, because of its imprecision, because of its absolute subjectivity, could not ground a conviction in law for a criminal offense. And why? Because it says that the person must be identifiable from a reasonable distance to a person outside the vehicle. Now, when you say identifiable, to what extent? You gotta see every mole? You gotta be able to make out there's a human being, or you gotta be able to identify the person specifically? And what if the particular police officer doesn't have the best of eyesight to begin with? And he says, well, I couldn't identify him. So who is this person? What are the characteristics of this person who has to identify an individual in the vehicle? And what is a reasonable distance, Mr. Speaker? Is it 2 feet? Is it 10 feet? Is it 20 feet? The law today, in terms of drafting, always errs on the side of objective standards when possible. And this is a case where it is possible. Because from the time we had tint, we've had tint meters. So why subject a person in a vehicle or the owner of a vehicle to a completely personal and subjective assessment when you set what the requirements are specifically? The measurable requirements are, it allows a judge, it allows a magistrate, it allows a police officer, it allows the person to be certain as to what the requirement is and what specifically is the standard that you have not met. Now, Mr. Speaker, we've been content to live with this imprecise law. And I don't know, Mr. Speaker, if you ever represented anybody charged with that kind of offense. But I'm sure that if you had, you would run rings around them. Let us begin with the level of the eyesight of the police officer. Whether outside was dark, outside was light. All these things, I mean, in no time at all, the conviction will be thrown out. Absolutely. But, Mr. Speaker, we do not have to persist with this poor approach to a criminal offense. A criminal offense subjects the individual who is charged and convicted with a blot against their character, with perhaps difficulties going forward in terms of what they might want to do in their life. And while we don't generally treat road traffic offenses in the same way that we treat other criminal offenses, the fact is that you now have a conviction recorded. We can do better, Mr. Speaker, and in every instance where we can do better, we should. Plain and simple. What do I mean by doing better? Well, Mr. Speaker, I can tell you that for many years, and you know, we talk about the big USA all the time. For many years, sir, every state in the United States has had standards for tint to be applied to vehicles. Now, I don't want to tie up the chamber with the technicalities, because the lower the number, the darker the tint. The lower the percentage, the darker the tint. And for those of you who are scientists and physicists and all those kind of things, the percentage that is used represents the amount of light that, that passes through the glass. So if you say 20% tint, it means that only 20% of the light will pass through the glass, and therefore it appears darker. A 70% tint means that 70% of the light comes through the glass, and you therefore have better visibility. That is, I hope, an explanation of how it works. So as I said, Mr. Speaker, and I did a little search on the internet. I mean, it's so easy to do. And in some states, Arkansas, they allow 25% tint for the front window, 25% for the side. I mean, so the point is, though, we don't need to go through all this. It is a common occurrence all across the US, in Canada, all across Europe, and even in the Caribbean, for legislatures to have stipulated what is the degree of tint that you are going to be allowed. Plain and simple. Plain and simple. Now, Mr. Speaker, we've heard every argument, well, but you're infringing on my privacy. What happens when my car seat fade? We've been told that. I like a dark tint, sir, because my car seat can last longer. Somebody said, but my baby is right in the back seat and the light can hurt them eyes. Every single possible excuse in the book for refusing to allow people to put on whatever tint they like on the vehicle has been put before us. Now, there are some instances, Mr. Speaker, where for medical purposes, and we have a doctor in the house, some individuals are especially sensitive to light. And therefore, having a darker tint will protect them. But you will see, Mr. Speaker, and I propose to make the draft regulation a document of the House, that there are going to be some exceptions to the tint rule, and some of those relate to medical conditions. And again, this is par for the course. So that the regulations, which are made by the minister and can't be made until this bill is passed, the regulation says that you can get exemptions from this requirement based on certification from a medical practitioner and so on, that you have a medical reason why you should have an exemption. So we have not gone into it blindly, Mr. Speaker. We are putting a reasonable framework in place. And I mean, there are a whole long list. I believe that relevant medical condition includes albinism, chronic actinic dermatitis, actinic reticuloid. These are not things that I understand. They're beyond my ken, but we went to the trouble of surveying the legal exemptions across the world, and these are the medical conditions that they allow. Dermatomyositis, that's obviously a thing of the skin. Lupus erythematosus, porphyria, and on and on and on and on. Photophobia associated with an ophthalmic or neurological disorder, or any other condition or disorder causing severe photosensitivity in which an individual is required for medical reasons to be shielded from the direct rays of the sun. So we have contemplated, Mr. Speaker, that exceptions are going to be available. But those exceptions do not include the upholstery of the car fading. They don't include that. Those are the kinds of things that we are not prepared to accept as exceptions. So what we have, Mr. Speaker, and as I said, I'll make the regulations a document of the House, the draft regulations a document of the House. We have a regime which says we are now going to be stipulating the level of tint that you can apply to a vehicle, but it doesn't apply across the board. You are allowed to have exemptions, and those exemptions include medical exemptions. But what is it? What is it that we are stipulating in relation to tint? In the case of the back car windows, the level of tint, the percentage of tint will be 25%. So that means that it is still reasonably enough to cut out some light, but 25% is the figure that we use in the back windows. 20% in the case of the front windows. So driver side, front side passenger, 20%. And then, Mr. Speaker, 70% in the case of windscreens, because you need the windscreen to be as visible as possible. So those are and we didn't just come up with these figures. We had meetings with all of our stakeholders. We met with all the people who own car fleets. We met with the people who apply tint. We met with police. We met with a variety of individuals, all of whom expressed an interest in the particular issue. And these levels of tint were accepted as being reasonable and appropriate to the task. In relation to visors, some windscreens will have a strip at the top, and we've made provision for that as well, which says on a windscreen less than 3 feet in height, 6 inches, where you have a taller windscreen, like in trucks and so on, you can have a 10-inch visor. So we've tried to go into all of those things. Now, the requirement for tint will not apply, the requirement for the tint standard will not apply to motor vehicles used by the President of Barbados, the Prime Minister of Barbados, the BDF, the police service, or the prison service. It will not apply to an ambulance. It will not apply to a motor vehicle for the transportation of human remains. And it will not apply to vehicles for which medical exemptions and other exemptions have been put in place. So, Mr. Speaker, we come back to, for want of a nail. The first point that I want to reiterate is that this is an issue that has been addressed globally, and it is high time that we approach it in a measurable, technical way, as opposed to the subjective, visible from a reasonable distance by somebody on the outside. The Barbados Police Service has bought a large number of tint meters, and the instruction given to them were that they should buy the best tint meters that money could buy, and that is exactly what they did. And they've already been trained on the tint meters. The same thing has happened in the Ministry of Public Works, their licensing office. They also now have these new tint meters, so that we can be sure, in the instance where a police officer has to stop a vehicle, that you can be sure that you're using a device that is globally respected and that will be accurate in its measurement. The other point that we wish to make is, even in other Caribbean countries, these measures have long been taken. Now, I don't feel that we need to justify it by saying what other people have done, but it should give us some comfort to know that we're not the only ones. So Trinidad for many years has had a requirement for tint. Jamaica, and they too have requirements, and in fact they say in Jamaica, no tint is allowed on the 2 front door windows in a vehicle, none at all. St. Vincent is about to pass legislation requiring percentages of tint. St. Lucia, they have a tint requirement. Guyana has a tint requirement, a tint stipulation, I should say, Antigua and Barbuda. So in several countries across the region, several of which are smaller than ours in terms of population, GDP, numbers of vehicles on the road, so other countries have gone this way. So we are not really blazing any new trail. Other countries have gone this way. It is important that we do it, not to follow pattern, but it is important that we do it so as to firm up the regulatory framework, bring certainty to the criminal regime in relation to the offense that a person commits if they don't have the correct level of tint, and that we provide this as a part of dealing with crime in the country. Now, Mr. Speaker, the amendment that is before the chamber is an amendment to the Road Traffic Act. And this amendment does not say you shall have tint of no more than this percentage or less than this percentage. This amendment really says that the minister may by regulations prescribe the circumstances in which a person who contravenes an offense, commits the offense, they have the opportunity to discharge the liability either by paying a fine, paying a fixed penalty on a daily basis, and the remediation of the particular contravention. Nowhere in this amendment does the word tint exist. What this does do is to empower the minister to make regulations for the tint and to provide a regime which says if you do not comply, you will suffer a fine. And if you continue to run afoul of the requirement, that fine is $500. So if you are not compliant, you can be fined, you'll be served a notice, and you pay a $500 fine. For every day that you continue in contravention, you pay an additional $10. And then you must also remediate. So you don't just pay a penalty and go along. You are under an obligation to remove the tint and to put on tint in compliance with the Act. Now again, sir, this reflects a new approach to how we treat people who run afoul of the law. A person who walks up to somebody and stab them or chop them up or shoot them, that is one kind of offense. But a person who puts on the wrong level of tint on his car, there's no animus to be a criminal there. The act of having the wrong tint applied does not make you a criminal. Maybe the purpose why you might do it, but not the act itself. So rather than clogging up our court system with cases, and you know, sir, that is what we've been doing in relation to a lot of administrative penalties, taking them out of the court system. You get fined, you pay the fine, and go on about your business. The court system is not clogged up. Police ain't got to come court week after week after week dealing with adjournments to give evidence. In a case like this, you pay the fine, and that is it. This is the gold standard, really, in relation to administrative penalties, and that is the approach that we're taking here, and it is the approach, Mr. Speaker, that you will see coming very soon in relation to other criminal offenses under the Road Traffic Act, what we call ticketed offenses. We're going in that direction. So the individual will not have to go to court unless they refuse to pay the fine. If they refuse to pay the fine, then of course they will find themselves before the court facing criminal charges. But the point is that this situation is being dealt with by way of an administrative penalty and not a criminal proceeding where you have to go and stand up before a magistrate and say guilty or not guilty. Today, what happens if you get charged under Section 27? That is exactly what you have to do. Show up in court. How do you plead? Guilty or not guilty? A policeman comes and he gives evidence, oh, he saw this vehicle and so on and so on, all the cross-examination, all that kind of stuff. You don't know where it can go. In this instance, you don't involve the courts at all, only if you are so contumelious that you continue with the breach, don't remove the taint, things of that sort. I can tell you, Mr. Speaker, that we are ready. There have been some delays before coming to Parliament, but I'm happy to say that we are in this place today, and we are currently reviewing the exact date when this will come into place, and I expect to be able to, I believe that the substantive minister who deals with the Road Traffic Act will be able to say what that date will be when she rises to speak in this debate. This, sir, is an amendment to the Road Traffic Act, which ordinarily has nothing at all with the Office of the Attorney General. Every road traffic amendment really is moved, led by, and is under the remit of the minister responsible for road traffic. But in this exceptional circumstance, because it came as a specific request from the police service, it was felt appropriate that I should be the individual, not to be treading on my learned friend and my colleague, Deputy Prime Minister's toes, but to be able to present it from this particular angle. Mr. Speaker, I do not believe that this requires a lot of palaver from me. The public has been aware of it for quite some time. We've had a long discussion about it. They are aware that this is coming, and therefore I think that we now just need to get it done and have it on our law books so that the public can be protected, the users of the vehicle can be protected, we can have a regime that is predictable and certain, and of course the important benefit to the law enforcement authorities in the circumstances that I have outlined earlier. Mr. Speaker, I don't know that I can usefully add anything else to this debate. Should I need to, I'm happy to address any issues that might come up during the wrap-up. But as I said, I want to make the draft regulations a document to the House. And these draft regulations, do not require to be laid by negative resolution. They're just made by the minister. And therefore, until the minister actually signs them into law, they're not, they're not, I can only make them a document to the House. With those words, sir, I am grateful for your attention and for the opportunity to address this matter.
Honourable member, you'll have to move the bill read.
Beg to move that this bill be read a second time.
Honourable member, praise yourself.
I'm obliged to you, Mr. Speaker. I say this not by way of complaint necessarily, but to observe that for some time I have been receiving notice of the content of debates merely a few hours before the actual debate. I say it is not by way of complaint, it is merely to express that one wishes the administration to improve its business, and that certainly this side would have far longer notice as to the content of debates. But I will also add to that these matters of law present this side with no disadvantage. And perhaps members here will be surprised to also hear that when a lawyer speaks on law, there's nothing that he says that has not been said before, and there's certainly nothing, the corollary of that is that there's nothing he will say that will be thought of for the first time. The law is the law, is the law. It exists, and when lawyers speak on the law, they're not reinventing any wheels. They are giving their interpretation as to the law. But I would prefer that the administration of our business here should give certainly more than 24 hours notice that a particular debate will take place. I discovered yesterday morning that this would be the content of this morning's debate. But of course, one had heard for some long time that this matter would be brought before the Parliament. I confess that I am a little surprised that the government has had the temerity to bring it. I don't say courage, I say temerity to bring this legislation to the Parliament, since I think still it is a rather unpopular piece of legislation, and I think the government, I hope the government knows that. And I hope the government appreciates that there is still a certain public revulsion against this legislation when one considers its origin, and that is to say its local origin. Now, the learned Attorney General did begin by saying that today's business is presaged by a debate which took place, I think the learned Attorney General said, in September 2024. And he said that that debate was on law and order. I would like to go a little farther than the learned Attorney General and remind that not only was it a debate on law and order, but that it was a debate on violent crime, and that somehow the government managed to extract from a debate on violent crime further policy decision and legislation as we have today on tint legislation, and therefore seeks to persuade the public that this legislation today is in some way going to confront the issue of violent crime. Now, I know that this Parliament would be rather disappointed today if I did not remind this Parliament, and certainly remind the country, that within the last 12 hours, we have recorded another death by gunshot. You will notice, Your Honor, that I do not make any reference to the number of deaths, because it remains my position that we have
become a little too used to the incidents of death by gunshot or death by violence, murderous death, and we have now reduced that tragedy to a statistic. And we say it's the 10th and the 20th, as if those persons are not human beings. If it is the 20th death, it is the 20th human being. And so we must not ever become so comfortable in this country that human demise by murder reduces to a mere statistic. The unhappy and tragic reality is that we are losing our human beings, our young male human beings in the majority, to death that a parliament and a government hopes to avert that death. And so this most recent murderous demise is a reminder that this legislation is probably not well-founded, not well-constituted to meet what the learned Attorney General says was a debate began in September on law and order, and to that I add, on violent death. This legislation today, and I think this is a debate that the public has responded to in this way, that legislation on tint is not an appropriate response to issues of law and order. And it is not an appropriate response to violent, murderous death. Certainly, Your Honor, I consider that this legislation is a diversion. If you prefer the word distraction, sir, then you do. But I consider this legislation a diversion away from the really tragic national issue of murderous death, in which every week we are losing young male Barbadians to this tragedy. And it is a national tragedy. And the government, having access to its military options, do have a responsibility. And that is a debate that we have advanced for a number of months now. That while you do not blame a government for every incidence of murderous death, you also attribute to that government a national responsibility and an official responsibility to reverse this trend in which we are losing our young men, and in a few cases, our young women. And so the question we ask today, is this an appropriate response to the issue of crime, to the issue of law and order, and to the issue of violent death? I will quote the Attorney General, the learned Attorney General, although it is his view that this debate does not require any lengthy interventions. I beg to differ. I think that at a time like this, any debate, any law that is proposed to avert crime must be a debate that is heavily involved by every member of this Parliament. And it is a matter of some regret that the learned Attorney General reduces it to that of a situation in which there really is now a transfiguration of a criminal offense into a civil penalty. That is to say, where previously the Road Traffic Act may have, and I use the word may have permitted the courts to fine or imprison a person, this amendment here today transfigures that situation to one of a ticketed offense, a civil penalty, a civil infraction, and to be more explicit, into the payment of $500. The public needs to know this. Into a payment of $500, and for every day that that payment remains unsatisfied, a further $10 is added for each day that the delinquency continues. That is where we are today. Now, Your Honor, as I said, there's nothing here said by a lawyer that has not been said before. And the learned Attorney General knows, and you do too, sir, that lawyers make their submissions based on precedent. The law is a compendium of precedent. And so it is always our duty to explain to the public what we do, why we are doing it, and how we do it, and how we propose to achieve an effect. I note that, and I should say this, I should add this to what the learned Attorney General has said, and to emphasize to the public that what is proposed is not fully completed today. Even after this debate ends, even after the vote is taken, the matter remains incomplete, because the learned Attorney General has told this Parliament and this country that what happens here today is still subject to further ministerial intervention. In other words, the minister will make regulations pertaining to what will constitute this law. And the learned Attorney General did give a preview as to what those further regulations will be. I heard most of them. Of course, that there will be medical exemptions. Let the public be aware of this. We are here to explain as well, let the public be aware that there will be medical exemptions, as far as that is what I've heard this morning. It is also a matter of regret that what has been made a document of the House in that regard, I was not favored with a copy, so I had to make notes. Beg your pardon, sir. And that there will be exemptions in relation to public service vehicles and for persons who have medical conditions. But I come now to my own response on behalf of the office that I hold. Before a matter comes here as legislation, it is expressed as policy. The policy is articulated, sometimes within the private domain of a cabinet. Sometimes the private deliberations of a cabinet become publicized by way of public disclosure, media conference, and so on. This country was favored with that public disclosure, except that it is a public disclosure which is now memorable, not in a positive way, but for the manner in which it became publicized, and if not the manner, the content of that publicity given. At the end of that debate, the Honourable Prime Minister, I beg your pardon, the Honourable Prime Minister would have uttered the famous three-word sentence, "I want money." And no one denies that that was what I would term the ultimate prescription, the ultimate solution to the issue. As we said earlier, the issue was that of law and order, according to the Attorney General. I go farther and I say not only law and order, but violent crime. And those three words, in my view, were uttered to constitute the final resolution, I want money. I said I think it is a matter of some regret that that has been the prescriptive resolution to the issue of violent crime. How then do you reduce the debate on violent crime to the words, I want money? I think what the public wants justice. The public wants a solution. The public did not want that last night another young man would have died. And the public may well feel assured that the most recent death of that 24-year-old child is entirely unrelated to what this Parliament is doing today. That the 1st and the 20th may have had absolutely nothing to do with tint on the vehicles that traverse this country. And that is a reality that this government must embrace, must face. And that is why I say that today's intervention is inappropriate. It offers no solution. If the government wishes to prevent people from having tint on their cars, please, government, locate that legislation within a basis other than the issue of violent crime. I think yesterday as well, there was another shooting in St. Michael. Yes, there was. And has this country been told that that has anything to do with tint? And this is not to trivialize the discussion. This is the necessary exercise of causes and effects. Is tint the cause of crime? And what is the effect of this legislation today? I say it is inappropriate. I say it is unrelated. This legislation is unrelated to the issue of violent crime in any real and meaningful way. And that it seems that crime is so highly organized and sophisticated that whether we have this legislation today or not, it will occur. And that is why my position, Your Honor, is that this is diversionary. And this is an inappropriate solution to the pervasive problem that afflicts this country on a daily basis. I come back to the phraseology, I want money. There's a doctrine, and let me promise you, sir, that my response today will be rooted in political philosophy, in legal philosophy, and in statutory interpretation. That is the duty of a parliamentarian when he comes here. We don't come here as robots to just read legislation and to merely sit. We have a duty to explain to the public what we are doing. And we must never become apologetic for rooting our explanations in social policy, political philosophy, legal philosophy, which you and I call jurisprudence, sir. We must not be apologetic about that. We must not be apologetic about rooting our discussions in these academic and intellectual pursuits. Because legislation, the content of legislation, is academic and philosophical. And so there's never an apology to be made for reaching a standard. Because this country is entitled to standards. And this country is entitled to high standards. And I will pause and say that sometimes it also becomes a matter of regret that when one is engaged in the process of statutory interpretation, that is my training for the last 41 years, not only training, but practice. And I started the study of law many, many years ago. And I have never abandoned statutory interpretation as a separate academic pursuit and separate academic undertaking. It's a matter of some regret that the Parliament may contain some who do not understand what one is doing, and that those persons see it as some kind of a ritual, some kind of a stopgap measure. When one comes here and one is presented with legislation, and while trying to be modest about this, how modest can I be? It is a skill that lawyers have. And it is an additional skill that we have as parliamentarians, that we have the skill of statutory interpretation. And we share that skill with the Parliament, through you, sir, and the public, through this Parliament. And so if there are those who don't understand it, please give it a chance and give yourselves a chance to learn something. And you, sir, if you had a voice in here apart from the supervisory voice, the voice of presidency of this place, you would pause and say to those parliamentarians in here that there's various rules of statutory interpretation, and I will mention some. And I do this by way of educating the Parliament without being immodest, and educating the public without being immodest. The literal rule, the purpose rule, the golden rule, and the e justum generis rule. I don't have to spend 24 hours in a library before I get here to know those rules. I've known them for many years. But do not let me, Your Honor, threaten immodesty. I just want to say to this Parliament that one must never find oneself being met with the language of insult when one is going about the business of interpreting law and residing within the specialist pursuit of statutory interpretation. Today, Your Honor, that will be a part of my exercise, to explain this legislation, not only drawing on its political, philosophical origins, but drawing on its legal philosophical origins. And as I've said, sir, I got notice 24 hours ago, but I'm not disabled by that. I just wish administratively that the notice is given earlier as a matter of courtesy. So if there are those who do not understand what I do, how it is done, why it is done, please let the public hear and do not intervene in a highly specialized debate, with comments that are misguided and comments that really go beyond the bound of good courtesy and good decency. Let this Parliament elevate itself beyond that quality of personal attack, personal and professional attack. So today, Your Honor, you being a speaker, you being a trained lawyer of many years' experience, and not only a trained lawyer of many years' experience, but a lawyer who understands how the law functions. Please, Your Honor, I know that you will allow me to conduct myself on this legal enterprise, rooted in political philosophy, rooted in legal philosophy, because you know, sir, that the best lawyers are not those who can recite the strict rules of law, but the best lawyers are those who understand how to marry legal principle with social reality and political philosophy. And that is what this exercise becomes today, rooting the debate in its origins, in its political, philosophical origins, explaining this law according to the canons of legal philosophy, and then going on to constitutional matters. And Your Honor, I am going to come to constitutional matters today. I intend to be complete in this debate today. And unless time is an issue for you, sir, it certainly is not an issue for me. Permit me, Your Honor. I was saying to I almost said to the court, I was saying to the Parliament that it was a matter of some regret that to say you want money was inappropriate. But that disclosed a political philosophy that must now be of some significance. I don't think the Honourable Prime Minister said it by the words just dropping from one's mouth. It was said, and that it was said, and that it led to this legislation in which money will be collected, indicates, Your Honor, that it was not a set of wasted words when the Honourable Prime Minister said, I want money.
Honourable member,
Beg your pardon, sir.
you're making reference to a specific debate.
Yes.
Right.
This debate. Or you mean the I want money thing?
Yes, Honourable member.
No, it was a press conference, sir.
But you're speaking of it all the time as a debate.
I beg your pardon.
Because
Yeah, the
it
term used loosely.
Yeah, right. It connotes then that it was done in Parliament.
No, it wasn't done here,
So
sir.
please explain that.
Yes, I'm obliged to you, sir. That it was a press conference in which the entire public heard and responded to the words, I want money. And that, I am saying the words were not wasted because what is done here today by way of this legislation reveals that the government does intend to collect money. So that the Parliament today is remaining faithful to what the Prime Minister told the country in that press conference, not a debate. Well, I was using the word debate loosely. In that press conference, the utterance of the three words, I want money, I'm saying that this Parliament, this government keeps faith with the utterance of those words. By coming here today, ultimately, this legislation intends to collect money, not to collect money for this Parliament, but to collect money for the coffers of the government. And I will say this, I speak honestly, sir. When one has the honor and the privilege of public representation, one has a duty to speak honestly. And dishonest political thought does no one any good, neither the speaker nor his audience. Let us agree to speak honestly to the public. And it is my view that when the Prime Minister said, I want money, the Prime Minister must have been intending that the public coffers, the public treasury, would have been augmented or enhanced by these additional monies. That is a logical deduction that one makes, that there's a sense in which this would be a new tax, speaking liberally, using liberal language. And what is the consequence of that? The consequence of that is that if the Treasury has money, the administration can use that money to benefit the public, for the public good. Whether it does or not is another matter. But the concession must be made that when the Treasury has larger amounts of money, one may presume that it will inure to the public good. And having said that, Your Honor, by way of concession, honest concession, it brings one to this doctrine known as, this political philosophy, utilitarianism. And utilitarianism it's an ethical theory that judges the morality of actions based on their consequences, based on a result, an end result. And the focus is on the end result rather than on the morality of the action. That's the doctrine, that's the philosophy of utilitarianism. And you hear the term used sometimes loosely about utilitarian pursuits. A utilitarian pursuit is one in which one may say sometimes the ends, people state it casually in this way, the ends justify the means. In other words, it does not matter how you approach the good, except that what becomes important is that the good is done. So that you judge an action not by its rightness or wrongness, not by its moral content, but you judge an action by its outcome, if that outcome is good. That, Your Honor, is called utilitarianism. There are those who consider, beg your pardon?
Continue,
They are-
continue, please.
No, I thought he was rising to his feet. Thank you, sir. There are those who consider that utilitarianism ought not to be embraced, since along every step of the way, all actions taken by humankind, all, should be judged by their moral content. The utilitarian will tell you, well, you may criticize my means, but I want you to travel beyond the means that I employ and look at the result, look at the outcome. Look at the fact that I'm going to have a treasury which is enhanced, sometimes in the amounts of millions of dollars. And since the intervention, undue intervention came from where it came from, look at the opportunity to enhance the welfare treasury, for example. In other words, I collect this money from persons who have tint, but there are persons who endure poverty who will have access to greater sums. And a utilitarian will tell you, well, look at the outcome. Isn't that a great outcome? You may say that I have disadvantaged persons who had tint on their cars, but look at the end result. I have a treasury now in which I can dispense larger sums to those in need. So that, Your Honor, I criticize the basis or the location of this legislation today in utilitarian political philosophy. That the morality, and to be more precise, the immorality of the action is not important. It is the outcome that we must consider for its importance, the enhancement of the national treasury. And that, Your Honor, is the criticism with which I join in saying that this philosophy of utilitarianism is not a philosophy that ought to be embraced, because you must consider those who are hurt along the way. That before you come to positive outcomes, how many have suffered? How many persons would have paid $500 just for having dark windows? How many would be delinquent in the payment of that $500? I have to drive across Barbados every day trying to avoid the police or the wardens, knowing that an extra $10 is added. And that is the nature of delinquency. That is the nature of public suffering. The learned Attorney General did say that this legislation will save people from the blot of criminality, but that does not bring an end. That does not bring an end to the dilemma of the citizen. The citizen who cannot afford to pay the money will suffer. And not only will he suffer on the one day that he cannot pay the $500, I repeat, sir, if he remains delinquent for another 50 days, that is another $500. And 50 days is less than 2 months. It's not a long time. And so, along the way, to enhance the public treasury, there's suffering. And there's suffering because the original action, the original motivation to collect money remains immoral. It is immoral. That is my view, sir. It is immoral because it brings disadvantage and social disadvantage and financial disadvantage and financial dislocation against the lives of people. This is how a parliament needs to explain itself to the public. This is how a parliament ought to engage itself in constructive debate. This is how a government must come to a parliament and speak candidly as to the government's pursuits. With respect, and if I may say so myself, these are the kinds of answers we must offer the public. We must be able to locate our debates philosophically. Not because philosophical indulgence is any lofty thing. It is not. We all live our lives by a philosophy. Every day we pursue a philosophy towards improving our lives, towards survival, if you wish. So that we need to, we need to stop. When we hear the word philosophical, believing that that is something probably discussed behind you, sir, by 2 or 3 visiting philosophers. No, all of us are philosophers, all of us. Just 2 Greek words put together. Philos, sophos, love of wisdom. That is all it is. And every Barbadian is a lover of wisdom. He pursues his life according to precepts that he holds, according to his wisdom, according to his appreciation. But I will ask you not to permit me to digress, sir. The point is that it is my view that, beg your pardon? Whichever it is. The point is, sir, we have a duty as a parliament to explain legislation, to explain why we bring legislation, why the government brings legislation, and an opposition has a duty, if it believes that that legislation must be resisted, to resist it on a logical basis, a basis that is philosophical. The basis on which, the political and philosophical basis today on which I resist this legislation is that it is rooted in a philosophy which cannot be justified and defended, the philosophy of utilitarianism. Having the ends justify the means. The means, I repeat, Your Honor, are immoral. This legislation is exposing thousands and thousands of the citizens of this country who have no fault, who have no responsibility for crime, who have no responsibility for violent crime. This is exposing them to financial loss, and this legislation is exposing them to financial loss unfairly and unreasonably and illogically. How can a young lady who straps her precious child, 3 years old, in the backseat of a car with heavy tint, how must she bear responsibility for last night's murder or yesterday's shooting? Doesn't make sense. It is deficient in its logic. And I think the public knows this. And I think the public has explained for itself the illogic in this legislation, the immorality in this legislation, the pursuit of wrong, claiming that the aim is good. The only good, Your Honor, in this is that the Treasury will become enhanced. At whose expense? At the expense of over 100,000 car owners who must now leave home with their precious little children, take them off to school, go to a technician, leave the car there, have the tint removed that they pay to put on, either lighten the tint or have it removed altogether. That is an additional charge. So that they're not only going to pay if the police officer says the tint is too dark, even before that time comes. In this difficult time, in this very difficult financial time for this country, how do you justify a further financial imposition on over 100,000 people on the claim that this legislation will somehow prevent crime and that it will prevent violent crime? The public will not be persuaded. I certainly, Your Honor, am not persuaded. I have come to this Parliament several times before, and I have offered my own prescription as to how violent crime must be dealt with. And I have spoken of the strategies in terms of their immediacy of effect. The military is one, the legislative, the economic, that is to say socio-economic, and the cultural. And the military certainly is the most immediate. I am not aware, sir, that it is a wise, strategic measure to deploy hundreds of police officers, well, if not hundreds, let us say scores of police officers across Barbados dedicated to measuring the degree of the darkness of tint on cars. Some things simply do not make sense. Some things simply do not make sense. And in my humble opinion, it does not make sense to deploy police officers across this country and across this city called Bridgetown to stop cars and to measure the degree of darkness of tint. It is a misallocation of a precious police resource. And I think the public knows that. And as I've said, it is a grievous inconvenience. It is the most grievous inconvenience to more than 50,000 people who own cars. For them to travel to a technician in the morning, have the tint removed, or have it lightened, and then to go back the evening. Your Honor, we all like to speak of productivity. That is a day lost. That is a day lost from work. And so, Your Honor, I do not think that the legislation is rooted in progressive political or social philosophy. But the government has kept a promise. I have accused the government of the temerity of keeping this promise, and I still stay with that word. I thought that the government really had changed its mind, because this country had been promised, I think, since January that it would have come. A delay now of some 4, going into the 5th month, had caused me to come to the conclusion that the government had abandoned this ignoble project. It is an ignoble project. It is anti-people, it is against the interests of the people of Barbados, and more so, it is against the interests of the honest people of Barbados. A man or a woman who has put tint on their car without mischievous or malicious or criminal intent is now penalized in the name of a military pursuit. And I want to say, and to join with the public in congratulating the Barbados Police Service for using its resources, for using its technological resources in bringing literal arrests to many of the criminal wrongdoers. This legislation will not impact, I do not think, and I have the right to an opinion. This legislation today will have a greater impact in criminalizing the innocent than it will in capturing the guilty. That is what this legislation does. And I repeat, rooted as it is in utilitarian philosophies, it will not solve a problem. A utilitarian philosophy is inappropriate, and it pursues immoral courses to achieve a good. And the good becomes negatived by the immorality of the pursuit in the first place. I ask this government to consider that it is not only inconveniencing thousands of Barbadians, but that it is condemning. I don't think the learned Attorney General will want to hear the use of the word criminalizing, because it transfigures from the criminal to the civil, and I will deal with that very shortly. But it condemns far more than it will possibly capture by way of resolution of crime. I think I've made the point. But it is here as legislation all the same. And I dealt with the policy, and I located that policy in an inapt doctrine of utilitarianism. It comes here today, Your Honor, by way of an amendment to the Road Traffic Act. Again, we need to extend our voices to those who stand at the gate of legal interpretation, who do not know. And those who do not know will learn that when legislation comes to a parliament, that too, by its nature, becomes rooted in a legal philosophy. What are you trying to achieve? How are you going to achieve it? Why are you trying to achieve it? All those are philosophical questions that come to bear on the issue of legislation. Why are you doing it? Tell the public why you're doing it. There is a jurisprudential philosophy, that is to say a legal philosophy known as legal positivism. And that is a theory of law that posits that legislation, for example, is justified in itself. Again, the question of morality arises. That legislation becomes justified not on the basis of its morality, but on the basis sometimes of the power that a government has to implement it. That's what is happening today. And that is what happens in here just about every week, perhaps. And governmental legislation is never beyond the critical review of an opposition. And I don't know why. I don't understand why the government continues to show an intolerance to justified and constructive criticism of legislation, in spite of what the Constitution mandates this office to do. There is this abiding resistance and intolerance to criticism of legislation, and I will not resile. But I will say today, sir, that my criticism continues to be rooted constructively in legal philosophy. The legal philosophy that legislation which is based on legal positivism, which relates itself to its existence per se, which relates itself to the power of a government to do it and to call it legislation, that is what justifies it, that it has nothing to do with whether it is moral or not. I think you would remember, sir, I think Kelson, one of the famous legal positivists, that it is not whether law is good or bad law. It is that it is the law all the same. And that is a dangerous legal philosophy. That law is what a governing body, law is what a government, through this parliament, declares it to be, not necessarily what is morally just or good. And this stint legislation may well fit into that. In the same way in which the utilitarian philosophy seems to have guided the policy, legal positivism now seems to guide this legislation in here today. That it is justified by the fact that the government says we can do it without regard to its rightness or wrongness. And that, Your Honor, is my criticism of what is done here today in relation to this legislation. But that is not the end of the debate. That is not the end of the debate. Your Honor, please permit me to come to the legislation itself and to offer to you, sir, speaking to the public through you, a legal critique of this legislation. And Your Honor, I will do that by way of statutory interpretation. I think, in fairness to the learned Attorney General, he did also attempt to, in a sense, deconstruct Regulation 20, Sub-Regulation 7. He did attempt to deconstruct that. He did not do it exhaustively, but you will permit me, sir, to travel a little farther than the distance traveled by the learned Attorney General. So that, permit me, sir, to read on my own enterprise what the government proposes to do today. Now, it obliges me, therefore, to tell the public that there's a hierarchy of law here. There's a hierarchy of legislation. The learned Attorney General comes today to amend the Road Traffic Act. The Road Traffic Act is what we call the parent legislation. I'm sorry to do this to you, sir. You know exactly what I'm talking about. There are members of the public who don't, and unhappily, there are members in this chamber who also do not. So permit me to expatiate on this matter in relation to those who do not know. So you have an amendment today to what we call the Parent Act, the Road Traffic Act. And within that Road Traffic Act, or should I say separate and apart from the Road Traffic Act, is a body of rules called the regulations. And the regulations are subsidiary to the Act. The Act was made here, and you would have heard the learned Attorney General say today that the relevant minister, in this case I believe the Minister of Transport and Works, will have the authority and the power, which is legitimate and lawful power, to make regulations. The power to make regulations is lawful. It's a lawful power. It's legitimate. But regulations made by a minister are what we call subordinate to the Act. The Act is made in Parliament. Regulations can be made by a minister. But a minister does not have the power of a Parliament. The minister's powers are subordinate to those of the Parliament. I'm sorry to do this to you, sir. You know exactly what I'm talking about. Some of your members don't. The public also. Many members of the public do not know. Let us tell them, though. And so, what the Honourable Attorney General is doing today, he is amending the parliamentary law. We have told the public that there is parliamentary law, which is a higher law, and there is subsidiary law, which is law made by a minister. And I hope the learned Attorney General, having made it a document of the House, will permit me to see it within time so that I can address the public on it as well. Let us read what the learned Attorney General and this government is coming to do today. Thank you very much. Is coming to do today in relation to the act of Parliament. On behalf of this Parliament, this is what the learned Attorney General is doing today. This is the learned Attorney General's intervention today. What is interesting is that what we have been presented with today describes itself. There's a rubric, there's a subheading which says discharge of liability for contravention of regulations. Discharge of liability for contravention of regulations. What the law is doing today is that it is removing, as the learned Attorney General said, it is removing criminal liability from the citizen and replacing that criminal liability with a civil penalty. You heard the learned Attorney General say the present law potentially places a blot on the character of a person who is convicted. In other words, he has a conviction card. What the government proposes to do today is to remove the prospect of a conviction card and to replace it with perhaps what we call a ticketing system, as you have in the United States and so on, or a simple visit to the magistrate's court, as you do with parking tickets. You pay the $50 and you're gone. This one is $500 though, and I don't know why the figure is that high. And you would accuse me of digressing if I asked the government through you, sir, in a bountiful economy, why do you need to collect $500 from 100,000 people? But you will not accuse me of digressing. I'm going to leave that and come back to the main issue here. So that what the government is doing today, it is transfiguring a criminal offense into a civil penalty. That is what it is doing. Let us read it though, sir. This section applies to such regulations as the minister may prescribe. We've talked about those regulations that a minister may make. The minister has power to make regulations. I'm going to repeat that again because we have a way of forgetting. And if this is to be a teaching moment, I am proud to be your tutor. Notwithstanding any other provision of this act, the minister may by regulations prescribe the circumstances in which a person who, through the contravention of any regulations to which this section applies, commits an offense, may be offered an opportunity to discharge any liability that would arise out of a conviction for the offense by the payment of an initial penalty of $500, B, the payment of a further penalty of $10 for every day or part of a day that the contravention continues, and the remediation of the contravention. What all of that means that where previously the legislation criminalizes the legislation, the act that was made in this parliament, and not this particular parliament, because the legislation is old. I think the legislation probably dates back to the 1980s. But the legislation said, or the legislation had prohibited previously in the regulations dark tint. The public may ask, well, why is it an issue all of a sudden? If it was on the statute books, why is it only to be implemented today? That's an interesting question, and there's an answer to it. I will come to it. But all that I have read, Your Honor, is consistent with the Hague Note. That, as the learned Attorney General said, the government will no longer be criminalizing, it will be penalizing by way of a civil fine. And let that be a summary of what is being done today. But let the public hear again, that for tint that is above, I think the degree may be 20%, above the degree of 20%, is to result in a fine of $500. How drastic? How severe? How inconvenient to the lady who drops her child off at school, has to take the car to be done if she chooses to do it. And if she doesn't, if she does not, $500 and $10 for every day that she remains delinquent. Let the public judge. Let the public judge. I have a job to do in here. And my job is not to support what I believe is inappropriate legislation. That's not my job, not to support it. To scrutinize, to analyze, to criticize, and when necessary, to chastise. And today it appears that I am duty-bound to do all four, because I cannot support this legislation. It is useless. It falls out of proportion to any remedy needed to resolve the issue of violent crime. This is inapt. This does not solve violent crime. But, Your Honor, let me come back to the legislation itself and the mechanics of the legislation. I dealt with the Act. I come now, Your Honor, to the regulations. As I said, the Learned Attorney General has amended the Act. And the Learned Attorney General's business has been to transfigure criminality into civil wrongdoing. That sums it up quite nicely. So if the Learned Attorney General wishes to say, I've done my duty and walk away with relative innocence, that is his right. That may well be his right, but I treat this government as having collective responsibility for all that is done here today. Let us come, Your Honor, to the regulations. I will concede to you, sir, as I just did, I'll do it again, that the regulations, which, as I have said, are a subordinate tier of law. These regulations have existed for many, many years, and I will deconstruct it, sir. Regulation 20, as the Learned Attorney General said, sub-regulation 7 is the regulation that causes all of this business today, sir. Permit me to read it. The glass of all windscreens and all windows on the outside of every motor vehicle shall be made of safety glass, and the owner of the vehicle shall not permit the glass to be tinted to such a degree as to make the driver of the vehicle unidentifiable from a reasonable distance by a person outside the vehicle. The Learned Attorney General did himself deconstruct that in part. What the public needs to be told, though, is that the regulation, which I've just read, condemns the owner. The owner, and it is important to make that point so that the public is aware that if you hire a car and the police officer stops you doing his duty and wasting public time on an issue that is relatively harmless, relatively I say, and you've hired that car, you're not the owner. So let the public be aware that the offense refers to ownership and not drivership. That is the first matter of awareness that the public should have. The public should also be aware, sir, that vehicles that have been imported with the tint, I don't know what is the term, the tint baked in to the glass, they cannot be liable because the legislation says where the owner makes it that way. So if it is above the prohibited degree of darkness, and it has been imported with that darkness, what's the term, remember? Infused, good word. Infused. Excellent word. Ingrained, infused. That there's no penalty because it cannot be said that the person made it that way. And I say that for this reason. The legislation says the owner of the vehicle shall not permit the glass to be tinted. So that if he did not permit the glass to be tinted, if it came into the country that way, and he did nothing, well, you can't lighten it. You can only darken it. If, of course, he darkens it, well, that's another matter. But we've had these questions from members of the public. And it's a good question. It's a good, fair, and reasonable question. If it comes in with that tint ingrained into the glass, the prosecution doesn't have a case against you. It is where the owner, not the driver, it is where the owner causes it to be transformed. Indeed, the legislation says, permitting the glass to be tinted to such a degree as to make the driver of the vehicle unidentifiable from a reasonable distance. The learned Attorney General did apprehend that there's legal difficulty there. And you know what the learned Attorney General was doing. He was interrogating the issues of subjectivity and objectivity. Anytime you see the word reasonable in law, sir, you know what that invites. It is an objective test. Reasonable, the concept of reasonableness associates itself with the question of objectivity. In other words, not the particular officer, but the reasonable officer, the average officer. So that an officer who has bad eyes may be judged by the standard of an officer with good eyes. So you can't say that the bad eye officer charged me and because he couldn't see, whereas another officer could see. It's an objective test. So whether the officer has good eyes or bad eyes, the distance must be that reasonable distance by a person outside the vehicle. What we will not miss is this, Your Honor, that again in deconstructing the legislation, the focus is on the driver. The focus is on the driver, not the passengers, not the front seat passengers, nor the rear seat passengers. It says, it speaks about making the driver of the vehicle unidentifiable from a reasonable distance by a person outside the vehicle. I wonder if it has not been a legal oversight. The original legislation obviously focused on the driver. If this legislation is to be confronting a contemporary issue, it ought to have, and this is my right to criticize it, having scrutinized and analyzed it, that it ought to pertain to all occupants of the vehicle, so that I would urge the learned Attorney General, after consultation with the members and the Commissioner of the Barbados Police Service, who should not come back in here, being interrogated by the Honourable Member for St. Philip South. Never do that again, sir. So that, thank you very much. So that the government may wish to return, and if it is to be convincing, amend the legislation, and I don't know why I'm doing this for the government, but if the legislation is to make sense, let it apply not only to the driver, but if you claim that it is to apprehend criminal wrongdoing, it must extend to all of the occupants of the car, and most certainly the occupants in the rear seat. If we are to understand what we think we do about criminal wrongdoing. I know very little about criminal wrongdoing. I'm not a criminal. So I don't know the modus operandi, but I base it on things that you read and you hear and so on. But let the public be aware that thus far, the legislation attempts only to deal with citing of a driver and not with citing of persons in a rear seat or even the passenger in a front seat. But I have a little more to say on this issue of statutory interpretation. Now, I want to propose to the people of Barbados that the original regulation is not a criminal offense. I am bold enough to say that today, that what the government is proposing is criminal wrongdoing. We say criminal because we know it is a traffic offense, but anytime you can go to prison, it means that it is criminal. You just say traffic to demarcate it from the other criminal offenses, but this is as criminal as anything because people have gone to prison for traffic offenses. So let us use the broader term criminal wrongdoing. I have my doubts, Your Honor, that tint on windows of cars was ever, in the first place, a criminal offense or a traffic offense. And I say that for this reason, sir. You in this place are a judge, so I am addressing the judge today. We are aware that in the exercise of statutory interpretation, a marginal note is not a guide towards statutory interpretation. What do we mean by that? You know, sir, there are some marginal notes. Sometimes you read in legislation, anyone in here can look and see. And there is in the margin next to a certain section, we're all legislators, we're all lawmakers, so that we have a duty to know how the law is written, how it operates, and how it extends and applies to the public. So that sometimes you see a piece of legislation and it has in the margin next to a certain section, offenses. So that the courts will tell you, oh, well, that word does not indicate that those are being created as offenses. And they'll say that for this reason. Because in order for a stipulation to constitute an offense, it must prescribe a penalty. You know that, sir. So that maybe the courts have been saying that the use of the word in the margin is superfluous. But I still believe it means something. That if a marginal note describes what is within that section as offenses, it must be an offense, although it is required to state a penalty. But here, sir, next to the section that includes the matter of tinting, it doesn't say offenses. It says requirements. Although the courts say what they say, and you are my judge today, this one says requirements. Now, the use of the word requirement must speak for something. Something. Now, I just told you, sir, and I'm sorry that the public has to hear such technical matters, so I will try to break it down. Yes. A stipulation is not considered in law to be an offense. That is to say, a stipulation in a piece of legislation is not considered to be an offense unless it prescribes a penalty, which is to say a fine or imprisonment. You and I know that to be the law, sir. in this section, in this Regulation 20, there is no such, there are no such words that say that it is an offense, except, sir, that Section 109 of the Act beg your pardon, sir. Section 109 of the Act says that, let me find it, sir. Yes. Section 109 of the Act says, now, I go back. I have submitted, sir, that tint is possibly not an offense. And that is not to collide with the government. That is to challenge the original draftsman. This government did not draft Regulation 20, so there needs to be no present sensitivity in here today. Knowing that this government is very sensitive on every bit of criticism. So government, please shed yourself of any sensitivity today. I am saying that Regulation 20, which deals with tint, is probably not an offense in the first place. But Section 109 of the legislation says, any person who commits an offense under this Act or the regulations for which no penalty is specifically provided is liable on summary conviction to a fine of $1,000 or to imprisonment for a term of 12 months or both. So that 109 is capturing all matters in the Act and in the regulations.
Is omnibus?
Oh, we have a good judge in the House. The omnibus provision. So that it is possibly an omnibus provision, except, Your Honor, that it is my respectful submission that Regulation 20, Sub-Regulation 7 is not an offense in the first place, because the omnibus provision at Section 109 of the legislation refers to offenses under this Act, whether in the Act or in the regulations. I choose to exclude, not I choose, I am excluding Regulation 20, dealing with tint, because Regulation 20, according to my respectful submission, is not an offense in the first place. It is merely a direction given to the public as to the standard that a vehicle should reach. In other words, it is my submission that Parliament at the time never intended tint to be an offense. It merely describes it in the marginal note as requirements. Let us hear what are those requirements in Regulation 20, for example. Not only does it speak about tint, Regulation 5, for example, says the following vehicles may be fitted with a gong, bell, or siren for the public, for general or special use, fire service, police. That is within the genus of requirements as tint is dealt with. I don't think Parliament at the time intended to penalize or criminalize the fire service or the police force at the time for having a vehicle that wasn't fitted with a gong, bell, or siren. Could not have been intended to be an offense. It's a direction, or as the legislation says, it's a requirement under this legislation, because the legislation intends to regulate the use of motor vehicles in public spaces. So matters of tint, matters of having bells are requirements. It is merely setting a standard, it is merely establishing a standard in relation to the use of vehicles in public places, never intended to create it as an offense. That is my respectful submission. And I'm saying to you, sir, that the question of tint falls within that genus of events, that genus of requirements. Let us go to 8. Every motor vehicle other than a motor vehicle or motor bicycle shall be equipped either internally or externally with a mirror, so constructed and fitted to the motor vehicle to assist the driver of such motor vehicle, if he so wishes, to become aware of traffic to the rear of the vehicle. Again, Your Honor, in your many years of practice, I don't know, how many persons have you represented having been charged for not having a mirror on a motor bicycle? That may be beneath you, sir, but I think you will answer the question all the same. And I hazard a guess that you've never represented anyone.
Honourable Member, you would be very wrong.
Beg your pardon, sir?
You would be very wrong.
I would be wrong?
Very wrong.
Wrong. Oh, you have? Oh, I see. So you're not above that kind of thing.
Honourable Member, even in relation to the same thing. Even in relation to the same thing, just last month.
Last month?
The
Oh,
same
it's good to
section,
see that you're still...
the same section that you're making reference to, Honourable Member.
You're still rubbing
was
shoulders.
charged, yes.
Yes. But these are not matters that proliferate in the courts. Well, having said that, you may now wish to add to that you represented the driver of an ambulance who did not have a gown. And I suspect you did not. Because the police do not treat these as criminal offenses. As the regulations say, there are mere requirements. You're merely requiring people with vehicles to reach a certain standard. The legislation is intended to regulate the use of vehicles on the public roads. That is all it is intended to do, and it never intended that this should be an offense. So, with a legal answer that may be available, that is my position. That the question of tint falls within the genus of standards that do not constitute themselves as road traffic offenses. These are probably not road traffic offenses. But if they are road traffic offenses, Section 109 does make them offenses. But it still is problematic. And it is problematic for this reason, sir. I go back to the original point. These are mere requirements. But if a court should find that they are offenses, and I would argue strenuously that they're not, that they're mere, as the legislation says, requirements to reach a standard, but if a court says they are offenses, the government's dilemma is still not resolved. And here's why the government's dilemma is still not resolved. The Constitution, sir. This is the constitutional argument. Under the Constitution of this country, and let me pause and say, I say this in here so often, not for the sake of the Parliament, and certainly not for you, since you know, the state divides itself into various institutions. The three main institutions of the state are as follows. The Parliament, which makes laws exclusively, having the power to make those laws exclusively, and if there are other persons or bodies empowered to make law, those powers derive from this Parliament, which may have passed an act ultimately giving them power to make laws. So that there are some public officials who have the power to make laws. The Chief Town Planner, in asking you to build within a certain distance from your boundary. The Commissioner of Police, who is empowered to redirect traffic when persons make applications to have road races and so on, or rallying. That is a lawmaking power that he has, but he derives it from a higher law that came from this parliament. So, the three main institutions that constitute this state are the parliament, the cabinet, which runs Barbados, governs Barbados on a day-to-day basis, executive policy we call it, running schools, having meetings with the police service and the defense force and dealing with the Ministry of Health, all administrative or executive acts. And the third institution is the judiciary. And it is the judiciary, sir, that I wish to focus on. As you know, this thing we call the state is a human community that enjoys sovereign power to manage the affairs of the entire country. And that sovereign power is divided between a parliament, a cabinet, and a judiciary. We call them separation of powers. And it does that by the doctrine of separation of powers. Not a big word. All it means is that the powers given to these three institutions must remain separate. A cabinet cannot exercise parliamentary power. A parliament cannot exercise judicial power. And although a parliament and a cabinet are what we call incestuously constituted, which is to say, cabinet derives its membership from the parliament, those powers under the Constitution are still separate. But there's that incestuousness in the relationship between the cabinet and the parliament. We accept that. But here is the separation that does not contain any incestuousness of relationship, the judiciary. The judiciary is definitely beyond the reach of the parliament, and it is definitely beyond the reach of the cabinet, except that the cabinet participates in the appointments of members to the judiciary. And when that happens, when that episode closes, the episode of appointment closes, there is to be no interference from the parliament into the judiciary, from the cabinet into the judiciary. They enjoy separate powers. And that is why the doctrine arises, separation of powers. That is done to avoid power being concentrated in one person who has participation in all three. You call it separation of powers. I have told that long story to say this, that the power to impose fines is a judicial power, exclusively a judicial power. It is not an executive function. The original legislation made it a judicial function. The original legislation, Section 109 of the Road Traffic Act, created offenses within the Road Traffic Act and said that if those offenses are committed, a court shall have the power to impose a fine or imprisonment. A minister does not have that power. And therefore, the point being made today is that if this legislation purports to give a minister that judicial power, it means that the minister is trespassing on the premises of the judiciary. And that, Your Honor, is unconstitutional. That, Your Honor, means that today's amendment is unconstitutional. In other words, Your Honor, when the legislation says, when today's amendment says that what used to be a criminal offense, and it is made a criminal offense only because a court pronounces that a criminal offense has been committed. Parliament prescribes criminality, but that criminality is tested in the courts, only in the courts. And it is only a court that may impose a fine or a term of imprisonment. That is exclusively a judicial function. The cabinet cannot imprison, the cabinet cannot fine, the parliament cannot. This country who have dark tint are honest and innocent people who just wish to protect and preserve one of the major investments that they will make in their life, even if they change the car. A car in Barbados still, it may not be a luxury now, but it is still a cherished possession. And I want to say to this government that it is trespassing on financial and economic rights of the public in its enjoyment of its private property. And that is not to make a constitutional point. That is to make a financial and an economic point. That this legislation is an unnecessary trespass against financial rights. And the point is, why should anybody wake up whenever the regulations are passed? Why should anybody wake up on July 1st and be exposed to the payment of $500 a day simply because he has tint on his car? That is the ultimate question that the public is entitled to ask. That is the ultimate issue that the public is entitled to resist. It is a matter that is worthy of public resistance. I am not condoning civil disobedience. All that is left for me to do, sir, is to ask the government humbly to withdraw this legislation as a nuisance piece of legislation and a necessary imposition against an innocent public. This will not solve any criminal wrongdoing in Barbados. It certainly did not prevent the last death of a 24-year-old child last night. It did not prevent the shooting of an honest citizen in the Ivy yesterday. It did not prevent those other 19 persons who lost their lives this year to murderous wrongdoing, nor the 50+ who lost their lives last year and the years before, when the numbers only dropped because of a COVID restriction. Criminality in this country is on the rampage. Where lies the fault? In tint? It does not, sir. It does not. And that is where the logic is brought to bear on this issue. Criminal wrongdoing does not have its roots nor its causes in the affixation of tint on people's windows. I ask the government, please withdraw this legislation and let the good, honest, and innocent people of Barbados carry on with their social and financial lives without this disturbance from a government which is merely pursuing acts of diversion to compensate for its gross inability to bring the question of criminal wrongdoing under control. This will not do it. This will not do it, Your Honor. You've been very patient, sir. I'm obliged to you.
Honourable St. Michael, South Central.
Thank you, Mr. Speaker. I rise to share some thoughts on these proposed amendments, but in doing so, perhaps to restate, as the Honourable Member for St. Joseph, the Honourable Attorney General has done, what is in fact clear for the Parliament to see, which is that this is an amendment to the Road Traffic Act. This conversation can be, and perhaps should be, situated in that context. Sir, to the extent that, and I set aside whatever other purposes or ultimate purposes the government has determined this legislation, to which this legislation will contribute. Setting aside those other purposes, the fact is that one of the things I have certainly heard in this conversation from the public is no one knows what is the level of tint that is acceptable. That is a road traffic legislation conversation. And so I consider that it is not out of order to bring clarity to that question. That it is not out of order to bring clarity to the question, sir, I have a tint shop in Halls Road. I have them in other places across the constituency, and there are other places across St. Michael. It is not out of order or out of the question that a government should seek to bring clarity to that question. So perhaps let us start there. And these amendments seek to bring clarity to that question. Sir, the question of good order and predictability on our roads will arguably contribute to a number of goals. I am concerned today, sir, with the overall question of citizen security and citizen safety that is made possible through these amendments. The Attorney General has offered one potential outcome or impact on citizen security and safety. And to the extent that I am not an expert on these matters, I will not trespass on these matters. But I am interested in the question of good order on our roads. And that is what road traffic legislation, as we have come to know it in Barbados, concerns itself with. When it comes to the question of tint, I will tell you, as somebody who walks about a lot in St. Michael, South Central, and other places, that one point of usefulness I see has simply to do with communication between a pedestrian and a driver, communication between drivers on the road. Sir, this has happened to perhaps every Barbadian that walks around. You stop, even at a pedestrian crossing or otherwise, a driver is telling you, hurry up, come along across. Sir, I don't move unless I can see you. Unless I can see how you are communicating with me, I am not going to take that step. And so, setting aside whatever other purposes the government has determined that this may support, let us talk about this as a matter of good order and predictability for Barbadians on the road as road users. But sir, apart from this question, there is arguably an entire suite of action that falls under or falls within the context of this legislation that must come together with amendments such as these to give real life to the question of citizen security and citizen safety. And this is perhaps one of the matters on the edge of that question. The matters that I consider to be at the heart of that question have, for example, to do with things like introduction of the breathalyzer test. Now, there are Barbadians who may consider these amendments and say, fine, I have no issue with these amendments. But further to these amendments, how is our safety being protected by ensuring that the people who get behind the wheel every day are of sound mind and capable to operate a vehicle safely on the road? Sir, there's the question of the increasing use of mobile phones, which is already in the law, but perhaps what happens to us all as Barbadians is that we start to fall back a bit from the standard. Sir, when seatbelt laws were first introduced in Barbados, there was an uproar. When we insisted that people wear helmets to operate certain vehicles, there was an uproar. But Barbadians, understanding the good sense of these changes and the extent to which it will protect them and their loved ones, complied and kept that compliance at a high level. Perhaps less so with the mobile phone usage. And my colleagues in here may raise an eyebrow at me, because I am sure that some of us may be guilty, as busy as we are, being sought for conversations from our constituents as often as we are, may sometimes let it slip. But the fact is that that moment of distraction on the road is perhaps a moment that leads to an unfortunate outcome through injury or death to oneself or to someone else. And so the question of introduction of a breathalyzer, that especially as the crop over season is approaching, helps keep us safe on the road, is one that, while Barbadians submit to this legislation to give clarity on the level of tint that is acceptable as a way to improve their safety, may also see that the introduction of the breathalyzer is perhaps a more robust way to be able to do that. I realize that we have normalized going to a karaoke and having a drink and getting in our cars. We used to normalize a lot of things that we since had to set aside and abandon in order to keep ourselves and our families safe. And so making sure that we are not under the influence of anything, alcohol or otherwise, before we operate a vehicle, is something that I believe that we are at the point of having to introduce. I am aware, as a member on the government side, of all of the reasons for the delays. I am not sure that bringing some regulation and regularity to fees in the taxi sector now stands as enough of a defense. I think we have to get on with it. I think often about the burden of enforcement that the Barbados Police Service has on its shoulders. The burden of enforcement is tremendous. We have heard from the Honourable Attorney General about the issues with attracting new recruits to the service. We have seen the work that the government has done to bring a sort of quasi-policing capacity through island constables and others to be able to pick up some of that slack. And so enforcement is a challenge for us across every sector where enforcement is required. Nonetheless, when it comes to making sure that motorists are operating their vehicles safely, it is something on which we have to insist. But sir, the question of good order and predictability on our roads extends, I believe, beyond the safety of pedestrians and communicating with motorists and making sure they can see them, make eye contact with them, beyond the introduction of the breathalyzer that is long past due, beyond making sure that people are not operating mobile phones in ways that are at odds with regulations that we have established. But it also has, quite frankly, to do with other areas of predictability that keep the country turning over. Sir, recently, we saw the announcement from the Barbados Revenue Authority that there was now a new way to renew your vehicle registration, what we used to call the road tax disc. And you do it online, it is a simple process, and it has been long in coming, and I'm sure Barbadians are thankful for it. But it seems, and this is as reported to me by my constituents on whose behalf I speak in here today, that this has now been overtaken by another bit of nuisance, which is to say that when it comes to transferring ownership on vehicles 10 years and older are to be inspected in the Pine by Licensing Authority inspectors. I seem to recall that this same Road Traffic Act was amended previously to establish certain garages and so on who could be authorized to do these kinds of inspections. I am not sure how that aligns with this, what seems like a practice of vehicles 10 years and older being inspected by licensing authority inspectors at the Pine location, and this being applied to change of ownership of vehicles. Now, the reason that we took the step, that the government took the step to authorize certain garages to do it, had to do with the capacity issue at licensing authority. And so, if it means then that for vehicles 10 years and older that are changing ownership, that they must go to the licensing authority, then that removes the usefulness of that amendment. Because it means that the bottleneck that we once saw would then be reintroduced. But I want to speak to another part of this issue, which is that there seems to be, and I put this here as a question that perhaps the responsible ministers, well, minister and the Honourable Member for St. Andrew, who works in that ministry, may wish to clarify for the public, which is that there also seems to be a practice or a habit of vehicles not passing inspection for things that really are not questions of the roadworthiness of the vehicle. So, for example, a constituent who advised me that he was told to paint his bumper because it was not attractive to the eye. There are structural issues in vehicles that mean that they are not roadworthy, that they are likely not to function on the road and cause issues. And then there are cosmetic issues that arguably a person who is hanging on to an old vehicle that they finished paying for, that they can't afford a new one, that they're just trying to keep on the road running so that they can do their work, cannot then be expected to go and come out of pocket to make it look pretty. So we have to be able to separate the questions of real roadworthiness from the questions of presentability that you might expect from public service vehicles. And so to the extent that we are today discussing a road traffic amendment bill, these are the kinds of things that are worthy of clarification to the public. Sir, the question of signage and making sure that people see and know clearly where they are going. You know, I don't know if we realize that signage is there to assist the road user. Signage is not just there so that when we are taking a stroll, we can say, oh, look, that's Baycroft Road. If you were looking for Baycroft Road, you won't find it because the Baycroft Road sign is today on the ground by a broken culvert that presents a risk to the people who use the area. The Rollock Court sign is equally on the ground. My neighbor from St. Michael South may be interested to know, because that is close to him, in my constituency, but close to him. I raise these things not just to give a list of maintenance issues related to signage, but signage is a matter of predictability for road users. If I am driving and looking for where to turn, it happens to all of us. You are driving behind somebody, and you say, but this woman driving very strange. They're like, they know where they're going. They're looking for the sign. These are fundamental bread and butter issues that contribute to good order on our roads and contribute to citizen security and citizen safety. Sir, I seem to recall that some time ago, and I will be short because this is really an intervention related to the suite of things, the package of measures that keep people safe. It's not just one thing. It's not just one thing. And I think that that's the point the Honourable Attorney General was trying to make in his own presentation related to law and order. My presentation, sir, relates to general citizen security and safety on the streets of this country as made possible through the Road Traffic Act. I seem to recall that we had once discussed a point system for road traffic infractions. And what does that mean? That rather than having a complicated court system, anybody who has owned or operated ZRs would know. And it is perhaps a bit of experience for which I am thankful. But many people who used to be in the business of operating public service vehicles and who have gotten out of the business of operating public service vehicles, ask any of us, is that having to maintain your good standing before the law is difficult if you're an owner of a public service vehicle. It should be difficult because there should be, by now, a point system where for every infraction, you are removing points that go against your license to own or operate. Just as in other jurisdictions, you lose points that eventually mean that you are no longer able to drive. You lose the right to have a driver's license and operate a vehicle on the road. And so, taken all together, these measures contribute to the safety of Barbadians and those who use our roads. But it is not just a question of tint. So introducing this amendment, though it may be useful, so that I could see the person who's telling me to cross the road and not take for granted that the fact that his tires are rolling more slowly means that he's telling me to cross, because that is an accident waiting to happen, quite literally. But to the extent that giving predictability to motorists, giving predictability to those who make their living by working with vehicles and providing tint to vehicles, to the extent that this has to be a part of a package that includes regulating and enforcing when it comes to the use of mobile phones and other distractions in a vehicle. Maintaining good, clear, readable signage so that people are not feeling in the dark, which is a habit that itself causes accidents. Being able to properly introduce and enforce a point system for traffic infractions. Being able to clarify the issue of whether we are really using garages for inspection of older vehicles and what really are the roadworthiness requirements for an older vehicle. This is not a question of cosmetic presentation because it is not a public service vehicle. And if my old car can run and it look old, well, let my old car run, because not everybody can afford a slick vehicle to operate on the road. As long as it is safe, let it run. Being able, sir, to finally, once and for all, introduce the breathalyzer test, even if it is on a pilot basis. Some years ago, I was in Trinidad for Carnival, many years ago now. And one of the things that was accepted and was common was that as you are going to one of the specific parties that you have to drive a long way to get to, you will expect to be stopped and tested. Because we know the spirit of Carnival, we know the spirit of crop over, fet to fet to fet to fet. And sometimes you don't check yourself to see if you're good. Well, let the authorities do it. And if we start, and if people know that at any minute they can expect it, then it starts to change behavior. Sir, it is time. There are too many accidents happening on the road that we cannot explain. There are too many walkers and runners and cyclists moving at 3:30 and 4 o'clock in the morning for exercise who are afraid because what? That is the time people are coming home from fetes. It is time for us to be able to explain and to hold people accountable. It doesn't mean that we lose the character of our Barbados, but I'll tell you what, you might go to a fete near home if you want to drink, because you might have to walk home. You do a lot less damage that way. Just walk in a straight line and go home, if you can make it. But don't get behind the wheel. That is not cultural, and I will not accept that it is cultural. Oh, Bajans know if they're drunk. Unless you have a different body than the rest of the population on earth, no, you don't know when you're drunk. No, you don't know when you're on the under the influence of any other substance. You don't know. Somebody has to tell you. And eventually, once we introduce these kinds of changes, people will start to get a better sense of safety and security because there is good order on our roads, and that is what this legislation supports. Sir, I'm obliged to you.
Honourable member for the Christchurch West.
Thank you very much, Mr. Speaker. I'd like to move that the House be now suspended until 2:20 for lunch.
The question that this honourable chairman be suspended until 2:20 p.m. All those honourable members in favor, please say aye. Those against, please say no. Meeting, the ayes have it. This honourable chairman stands suspended until 2:20 p.m.